Good afternoon, everyone. It's my pleasure to welcome you to our roundtable with Ian Connett, class of '07, and Paul Morico on from seed round to Series A. We appreciate you taking time out of your busy schedule to join us today. This event is organized by Trinity Entrepreneurial Network. As we all know, the Bantam spirit has always been entrepreneurial one. In our alumni body, we are proud to have many successful and aspiring entrepreneurs of all ages and in every career field. The Trinity Entrepreneurial Network, or TEN, provides a dedicated space for Trinity entrepreneurs to connect with each other and with current students. For more information, please contact Melissa Bronzino-Regan. Please check the chat for Melissa's email address. She'll put her email address in the chat. Today's program is a part of monthly series of Roundtable Conversation with Trinity entrepreneurs on topics that are interesting to fellow entrepreneurs. Before we begin today's program, here are the few housekeeping notes and announcements. During our presentation, we recommend that you set your view to speaker view and then switch to gallery view for our Q&A session. Please make sure that you're muted throughout our presentation. Our program will be recorded and available on our website later. So if you feel uncomfortable, please turn off your camera. Please feel free to use the chat to ask questions and offer ideas to our presentation. So my name is Isabdin Gavramariam. I'm a rising junior majoring in biomedical engineering. Trinity College has a student-led entrepreneurship club and I'm the social media chair. It's my pleasure to represent the other members of our club and to welcome them on our today's call. I would also like to tell you about the Bantam Career Network, or BCN. The Trinity Entrepreneurial Network has created a group in the BCN, which is the Bantam Career Network, for alumni and students specifically who are interested on entrepreneurship. This group provides a dedicated space that will allow students and alumni to ask questions and seek advice with other entrepreneurs. After this event, please complete your profile on the Bantam Career Network. The Bantam Career Network is like LinkedIn, but it's only open to Trinity community. It's a great way for all students and alumni to connect, so we welcome you there. If you have any ideas or other topics, or even would like to recommend a speaker, even if you want to volunteer yourself, please reach out to Melissa, and her email is in our chat. And finally, we hope that you share your feedback in our post-event survey that you will receive in an email tomorrow. Today, we are delighted to have with us Paul Morico and Ian Connett. Please join me in welcoming them.
Great, thank you. Ian, I think you're up.
I'm up, great.
Go for it.
Thank you so much. And thank you to all the Trinity community members who carved out some time out of their busy days today during a very busy time of the year to check out this talk with Paul and myself about our post-Trinity College adventures in law, supporting seed and Series A stage ventures. It's been a very unique and rewarding journey, and I hope you find this talk helpful. And I'm always here to connect afterwards if there's something we didn't cover, if you just want to connect and chat some more. It's really an honor to speak and share knowledge about my experiences with Trinity. And I just have to say, I'm really super excited about everything our college is doing to foster technology and innovation at both the curriculum and the alumni level, and even to create many platforms like this where we can connect, have these conversations, and who knows, maybe even help each other found and build some really great new tech companies in the future. Because I truly believe more than just technology or law degrees, it's people connecting that makes this stuff work really, really well. So before diving into some of the specifics about what it takes to grow a venture from a seed stage to a Series A and some of the legal risks and issues involved, Atsub and Melissa asked me to share a bit about my background on what led me to found Connett PC about 5 years into my in-house legal career. So just a little background info. For those who haven't caught up with me recently, Connett PC is my boutique firm that's been supporting seed and Series A venture-backed startups since 2018, when we onboarded our very first client to our outsourced legal operations or legal ops platform. to today in 2022, where our firm now actively supports the growth of several venture-backed clients who have collectively raised over $100 million in investment capital in that time. Really cool to see the ideas that walk through your door in such a short period of time. We've had everything from a biotechnology cancer screening tool that uses patented technology to lower the cost of cancer detection and make it more accessible, to my personal favorite. We're working with a seed stage venture right now that's a Latin American virtual food hall that's partnering with DoorDash to build a marketplace to deliver delicious Latin American cuisine straight to your front door. So really a diverse range of companies that we work with. And Paul's going to talk a lot about IP at the back end of this conversation. And when I started to think back on what really specifically led me to becoming an entrepreneurial lawyer who in turn supports entrepreneurial tech founders, there were three things that jumped to mind. First was getting real world work experience as an in-house counsel very quickly out of law school. I think that was one of the things that kicked off my entrepreneur journey, because getting the in-house experience really gave me a unique microscope on the inner workings of business, and getting the opportunity to listen in on board of director meetings, which not everyone always has access to, and investor conversations, and looking at the documents that were involved in making those investments. I really absorbed how companies were financed and then effectively run after those financing stages. Secondly, having the opportunity to work alongside technology engineers and disruptive founders, and sort of absorbing, I guess, what you could call a hacker mindset, or there's also this term design thinking, and applying that to the law firm model. When I started working, this was like around 2008 to 2018, there was a lot of technology happening, especially in my backyard in New York. And I got to see firsthand how companies were sort of breaking up old models. And the thought popped into my mind, well, how could we actually apply this to the law firm model? So as I began to sort of run and build these legal departments for clients, we found this niche of finding ways to apply technology to simplify legal tasks. This could be doing everything from using automation to help clients draft and execute contracts more quickly, which is actually really important after you're seed funded, because you've got to sign up customers, to helping clients leverage tools like Salesforce.com to track and manage contractual terms. Using that tool, you're actually able to save a lot of time because you can see everything in a structured database and you don't have to read multiple Word documents. So really kind of absorbing that hacker mindset and applying that to law was what sort of drove my entrepreneurial practice. And then lastly, I just really had a genuine sort of rewarding feeling in helping see our clients grow. I personally just enjoyed the strategic and relationship aspects of my client interactions, which diverges from the traditional law firm somewhat, where you sort of become an expert in a particular type of transaction or subject matter, or you end up going to court to argue, and that wasn't really ever my thing. So yeah, I realized kind of early in my career I wasn't going to be representing Johnny Depp or Amber Heard. I just didn't frankly like going to court, so thank God I discovered the startup world. And it's been really fun. Another really great thing about working with seed stage companies, especially if you get to a Series A or an exit, is that if everyone's still friends at the end, it becomes sort of a positive cycle of reward, where at the end of the road, it's not the beginning of the end, but it's the end of the beginning. And keeping these relationships going, you start to build up a network of startup founders and also venture capital investors who are sort of willing to take your call and can help you with the next one. So it's been really great just seeing how these relationships have evolved over time. And just sort of those three things all put together sort of led me to where I am today with Connett PC. So with that being said, I think, just we'll start with basics. What is a seed round anyway? What is that? And how is that different from a Series A investment? Well, to start, the seed round is an early stage investment of capital in a business venture. Sometimes they're actually preceded by something called a pre-seed or a seed bridge round. This is also called a friends and family round. But the seed round is essentially the very first sort of large check that's written to start your business and to take your business from the ideation phase into it being an operational actual business. The typical check size for a seed round is usually between $250,000 to up to $3 million. And they're usually written by the early supporters of the business. As you get more into the Series A level, the checks do increase to a typical range of $3 million to $15 million, but we're actually seeing Series A checks that are even larger than that amount nowadays. So, seed rounds are also supported by what is often called, angel investors or friends and family. But the seed rounds they can also be backed by sophisticated firms, venture capital firms that specialize in seed level investments. But the main point of your seed round is basically to start the company, get you to what's called an MVP or a minimally viable product. And then you use the Series A funds to scale that if it's successful. So to sum it up, if you're doing a seed round, think that's your starting point. We're turning an idea into a company, usually $1 to $3 million in investment. Your Series A is you're now trying to achieve scale and grow, turning that company into actual profits and a larger business. And those checks are typically between the $3 million and $15 million range. So we're going to get into some of the legal aspects of this, and then Paul is going to talk about intellectual property and why protecting your IP is very important as you grow from seed to Series A and hopefully beyond that point. So the goals, as we just discussed, between seed and Series A are different. And so the process and the legal strategies that are involved in trying to achieve both of those goals are also somewhat different. So we'll kind of start with the seed round, and I'll just share my experience in working alongside founders that have been successful in doing very fast seed rounds. You need to have what I would call 5 of the must-have seed round requirements. So just, you might be wondering, well, what is a fast seed round? Well, a quick story. We actually had one founder that we worked with about 2 years ago in the growing cannabis space who completed a $1 million seed round using an efficient legal tool called a safe note, which is a sort of a template investment document that was developed in Silicon Valley about 10, 15 years ago. Anyway, this individual was able to close the seed round in about 48 hours in one trip to New York City. He'd been laying the groundwork for many, many months before that. But if you sort of do this the right way and you're going about it in an organized, an energetic fashion, I've seen these things close in a very short period of time. And that's a very high bar. Typically it takes 1 to 3 months to get it done. But that being said, I think you need to have, based on my experience in seeing the successful seeds, you need to have, the 5 must-haves. So what are they? Number 1 is solid legal structure and some core legal documents. 2, you need a clear business plan, or what's known as the pitch deck, which will have several iterations. But that's definitely a must-have thing that you're going to need. 3, a credible advisory board and advisory contracts as well to support those advisors. 4, this is an obvious one, access to capital, a rich uncle or a rich Trinity alumni. There needs to be money, obviously, and access to that. And then 5, which Paul is going to speak more about, is novel intellectual property and a way to actually protect your intellectual property and your ideas so you can effectively commercialize it. So the 5 requirements, just to recap, for a successful seed round to get you to Series A are solid legal structure and core legal documents, clear business plan and pitch deck, credible advisory board and advisory contracts, access to capital, and then protected IP. So I'm going to quickly talk about, and very quickly, because I think I have about under 10 minutes left to go here, and I want to leave some time to connect with everyone and respond to some of the chats. But let's talk about the first must-have for your seed round, which is a solid legal structure and a document. So I've seen this happen quite a bit, but many founders forget to formally incorporate. It's very easy to do now. You don't even need to actually hire a law firm to do it. We've been able to do this quickly for our clients, but many clients actually just kind of do it themselves on tools like Clerky or LegalZoom. You absolutely have to be formally incorporated. I recommend the Delaware C Corp or an LLC, depending upon how many investors you're looking to take on. So definitely don't forget to formally incorporate. And also, as you do that, you're going to need something called a cap table. And a cap table is basically an Excel chart that shows how your equity pie is shared across your investors and your other future seed round investors. So cap tables are typically managed in Excel, but now there's software one that I recommend to clients that we actually manage on their behalf is called Carta, where you can actually see your equity sort of divvied up in a secure cloud. So you're going to need to incorporate, you're going to need your cap table, and then you're just going to need your sort of laundry list of basic, what we call corporate governance documents. Now, you don't really need to worry about having all of your commercial contracts and sort of like your employment contracts and sort of, the sort of plethora of contracts that you see if you go into due diligence. To do a seed round, you're really just trying to get the basics, the core sort of corporate structure done so that you can then use those funds to hire somebody like a Paul Morico to help you get more contracts in place to make sure that you're protected as you grow. So from a document perspective at your seed round, based on what I've seen, the things you really want to worry about and nail down are your certificate of incorporation and your initial bylaws. A stock purchase agreement, which is basically your agreement to purchase your stock, which is usually going to be a par value because there isn't too much business happening at this point. Your stock is basically worth the piece of paper that you're getting in what's called a stock issuance. You may want to consider executing a founder's agreement if you're working with multiple founders. And also I recommend having template NDAs ready so that you can have quick conversations with investors or with potential commercial partners. So having a nice, easy to use template NDA is also really helpful. And we actually help our clients sort of manage the NDA process. And having that streamlined is great because it helps to build momentum as you're having conversations and trying to raise money. You'll also, really importantly, from a legal sort of document perspective, there's just two more here and then we'll get on to the others because I know how much everyone loves legal documents. You're going to need a document for your investment itself. So the one that I mentioned before, which I really like and which I recommend if you're trying to do things quickly, is called the Safe Note. And I can tell you all about how Safe Notes work, but basically they're templates that were developed by an incubator called Y Combinator out in Silicon Valley, which allows you to make an investment in exchange for equity at a future date. So basically you can have a check that's written, deposited into your account, and it doesn't actually convert into equity until your next valuation round. So it allows you to sort of skip the initial sort of tricky question of valuation early on, allows you to get investment quickly using a template. It's really designed to be a template document without any edits or negotiation. And they're actually really quick and easy tools that have been used to found some really great large companies. The investment document will also vary depending upon how you're actually looking to raise capital. If you're looking to do an equity raise, you would be using something more along the lines of a convertible note. If you're doing a debt, it could be just a loan note. So, but any of those is better than a cocktail napkin, which I have also seen. So definitely want to make sure that you're paying attention to your investment documents in addition to the core legal documents that support your company. And then last but not least, there's actually a very, very small amount of securities work that needs to be done. It's called a Form D. And we do this for all of our clients that are raising money. And you file that with the SEC to basically give them some information about your company, the round that you're doing, and that allows you to basically comply with securities laws and make pitches and raise funds with what are known as accredited investors. A lot of early stage founders don't know about some of the SEC and state blue sky securities laws. So that's the last sort of piece of the puzzle, which you really need to think through to have it be a successful foundation for future rounds. So from a document and sort of like a legal structure point of view, I would say that's pretty much it. As you get closer to your Series A, it's way more important to have actual commercial contracts in place with customers, partners, and IP protections. And Paul's going to talk a lot about IP at the back end of this webinar. But for now, at the seed stage, you can just kind of get away with the basic corp package that I just described. And then you can use those funds to hire somebody like a Paul to make sure all the IP is protected as you grow. So quickly, in the 3 to 5 minutes that I have left here, I'm going to talk about the other must-haves for your seed round to put you in good shape for your future Series A. You're going to need a very clear business plan or what's known as the startup pitch deck. So this isn't a legal item per se, but it's kind of essential to raising your seed round. So I'm mentioning it here. And what I've seen with successful pitch decks and business plans is that you explain the problem and the solution in layman's terms. And what I tell my clients is, even if you're pitching to a billionaire or a big, scary venture capital firm, you have to explain your problem and your solution like you're talking to a 2-year-old child. It's just the way it is. People have very small bandwidth these days. Your seed investors are typically very busy people, and your Series A investors are even more busy. So if you do get an introduction and you have the opportunity to pitch, you're going to get one bite at the apple typically. So you want to make it count, and you want it to be really simple and clear. You also want your deck to very clearly explain how the initial capital will be deployed. Specifically, what are you going to do with the first $1 million that you get in the bank, and then having some projections as to return, preferably over a 3-year time horizon, is what I see. At the seed stage in your deck, a valuation is less important. Your company shares are going to be set at par value. As you get into Series A investment conversations, you'll go through a process known as due diligence, where you're going to need to have actual financial statements. You're going to want to basically have a valuation to price the value of the company. And you're going to need what's called a due diligence room or data room. That's basically a repository of all your legal contracts and documents. So your potential investor can do sort of a mini audit on your company and decide if you're right for a Series A. If you're doing a pitch deck, I highly recommend having it vetted by a CFO or a consulting CFO. I'm sure there's actually a lot of consulting CFOs within the Trinity network, but have that deck sort of practice it with somebody who is a CFO, who has a CFO mindset, preferably someone who's had some success in helping with fundraisers for other companies. So definitely recommend having that practice, and then having the CFO seal of approval before you sort of take that to the investment market. Getting a little short on time here, but just 2 more quick things we'll hit. You need a credible advisory board. I think that's really helpful at the seed phase. So these are basically individuals who are not on your board of directors, which are the people who are actually running your company, but these are advisory board members who typically get stock options and execute advisory contracts to provide you with sort of strategic advice, or just basically helping you to sort of get things going, and to help you in different areas of your business. It's really helpful to first-time founders because a credible advisory board can provide some credibility to your company if you're a first-time founder. And what you want with an advisory board are individuals who aren't just going to basically put their bios and their headshots on your website, but are actually going to do things for you. They're going to actually open doors. They're going to give you advice. They're going to help you get things done. And so how do you do that? Well, we recommend having your template advisory contract describe sort of consideration for what your advisory board members will be doing. So in exchange for what I typically see as a 2 to 3% equity interest, maybe less, that's probably on the higher end. You want to specifically put in writing what your advisors are going to be bringing to the table, and what it is they're actually going to be doing for your company. So last but not least, I'll talk about the final must-have for my end, and then we're going to give it to Paul to take us home with intellectual property. This is the most obvious one, but you need access to capital. It goes without saying, but you're going to need to tap into a network of those who have investment that are willing to deploy it in exchange for a stake in your company. So there's several ways to go about getting access to capital. One would be to attend more of these roundtables, because you never know who's going to show up. We encourage more people to sign up if they're in the startup world, or they have a startup and they're looking for Series A. Get connected with Trinity. We're here to help each other grow and find success and do great things in the world. I would also recommend engaging with lawyers like Paul and myself, who've worked with investors and startups in the past, who might not just be able to help you with some of these initial legal tasks, but we might also be able to help you get access to networks of venture capital firms, and actually help you present your case in a way that gives you a legal shine, what I call like a legal shine, or de-risking your investment in the eyes of your potential investor, because you've taken care of the legal tasks, you've formally incorporated, you have initial contracts in place, you have a cap table. Having a lawyer involved in the process, in my experience, doesn't typically hurt you as you're going about the seed process and then on to Series A. So with that, I am going to pause, and I'm going to kick it over to Paul to tell us all about how to protect our intellectual property as we seed and grow our companies.
Great. Thanks very much, Ian. I learned quite a bit, actually. The difference between seed and Series A was always confusing to me. And I think you gave a very clear distinction between the two. And so I very much enjoyed that piece. So a little bit about my background. I graduated from Trinity in 1987. I had a dual degree in mechanical engineering and mathematics. At the time, I was sort of weighing a choice as to whether to go into join one of the insurance companies in Hartford and be an actuary, or go off and potentially work for United Technologies or Combustion Engineering, many of the big employers in Connecticut. And in the end, I decided to do something completely different. I went to law school, and I went off to New York to go to law school. And when I was looking for my first summer job, I had nobody in my family had been a lawyer, and so I was looking for a summer job one summer. And back at that time, this was over 30 years ago, actually law firms looked and hunted for people with technical degrees. There's now a lot of people with technical degrees doing IP law, but back then it was much less of a commodity. And so I ended up working one summer for a patent specialty firm in Rockefeller Center. Enjoyed it enough, and thought that, well, this is pretty cool. I get to continue doing science while practicing law. And so spent the next summer at another firm in New York, and then sort of the rest was history. I ended up down in Houston because I met my wife in New York, and she was originally from Texas, and we came down here in 1994. My practice is both. I actually done a lot of litigation work as well as protecting patents. Early in my career, I worked on drafting patent applications. And then when I moved to Texas, the firm I joined had primarily a litigation practice. And so I ended up enforcing and filing lawsuits involving patent infringement, trademark infringement, and the like. And that still is a pretty big piece of my practice. It vacillates between 60 and 80% of my practice. Last year, it was much more heavily that way. But I've also continue to do a lot in the transactional space, including with startup companies. I do a lot of agreement work from sort of Fortune 50 companies all the way down to startup companies. And in fact, my wife's cousin left Halliburton he was a high-level engineer executive to start his own downhole production enhancement company. It's based on specialty chemicals. I decided to invest in that company. I'm on the advisory board, as Ian mentioned. I've performed that role for a number of my smaller startup companies, and that's a very valuable asset for many companies to get that. I do it sort of in exchange for stock. And I also serve as a general counsel. And I've invested in the company. I actually own the first 50,000 shares of stock in the company. So I kind of see it from all the different angles, and it's been sort of an interesting ride. So let's talk about some of the IP agreements and issues to look out for in your startup when you're starting up a company. Very often, the most critical asset you have in a startup is your intellectual property rights. It's the idea that you've come up with, and sort of the implementation of that idea. Other than that, very often there are no other assets in the company, and so it's critical to protect that sole asset. Now, it's not, I shouldn't say the sole asset. The other huge asset are the people. Yourself, if you're the founder, and your background, as well as the other employees that are working for you. And so one of the critical documents, and Ian alluded to this, that you really want to put in place are employment agreements with the other people that are working for you. As well as non-disclosure agreements with any third party you have. One of the biggest mistakes startups make is people are very excited about the technology, and they immediately go out and tell other people. Very often they tell investors about the technology. And they've done that before they've even protected the technology. They'll do that before they get the NDA in place. Anybody who's not an employee, the employees should have employment agreements with pretty tight confidentiality provisions. But then anybody outside of the company you talk to, you should have an NDA with, whether that's investors or third-party vendors or companies you're dealing with who might be providing software services in connection with starting up your company. If the one thing you leave with from today on the IP front is this, it is never too early to get an NDA in place. That's one of the most critical things you can do to protect your company. There's some value in getting non-compete provisions if you can get that with certain employees. It's often pretty hard to get those in any context, but if it's drafted narrowly enough, it'll be enforceable in court, and it's beneficial to have it. We had a number of folks in our startup company leave because it's been a little bit slower going, and while they haven't gotten into a competitive situation, I've had that happen with clients of mine where individuals left and started off a competing business. And so if you can get a non-compete included, even if it's for a year, that can be pretty significant in terms of helping yourself. Of course, on the patent side, if your idea is something that is easily replicated or understood from what you tell the public, often I tell people, unless it's a chemical formula which is difficult to reverse engineer, or some proprietary software, you're probably going to want to try and get a patent on it, and you'll want to file that as soon as you practically can. And there are some inexpensive patents you can file called provisional patents, which protect the idea for a year. And then as you raise money and have more money, you can flush out that idea and create a more robust legal document. It's critical that you do that early. You don't always have the ability to file your patent before you start having these discussions and raising money, which is why the NDA is critical. And the patent is kept confidential in the patent office for the first 18 months. And so that's why the NDA is hand in hand with the patent is critical. Some things like chemical formulas or software is best protected as a trade secret because the patent has a limited term. It's limited to 20 years from the filing date. Now, in most startups, that's an eternity, but in reality, most patents have their most value at the tail end of the patent term. Whereas a trade secret, so long as you're faithful in keeping it as a trade secret, could live potentially in perpetuity. But trade secrets are only as good as the confidentiality agreements. In connection with trade secrets, and that often includes, for example, object code. Many startup businesses are these days are web-based or are software-based. It's very important to protect the object code in the software, and you'll want to do that in a variety of ways. One is you may want to copyright it. You can file a copyright application with the Library of Congress. It's pretty inexpensive to do. Many often are concerned, well, what about, I don't want anyone to copy the code. And so you can file it in a redacted form. The Copyright Office will take redacted filings of software code where up to 75 or 80% of the code is redacted so no one can see it. And that gives you copyright protection, which gives you the ability to go after companies for copying your software, enables you to get attorney's fees and a whole host of other potential damages and injunctive relief that sometimes you can't otherwise get. Now you can have a copyright on your software, and you can also have in parallel with that trade secret protection. You can also have trade secret protection as an overlay to patents. So you may have, for example, a copyright and and a trade secret over your source code, but then have a patent on your broad level idea. And that gives you multiple levels of protection. By having the narrower protection with the copyright or the trade secret, you protect the specifics of your idea, whereas at the patent level, you protect the broad idea. Now, in connection with making sure you protect your trade secrets, again, as I mentioned, you'll want to have NDAs in place. You'll want to make sure that only a handful of employees get access to the information. In our startup company that I'm involved in, only the COO and the CEO had access to the information, to the highest level trade secrets, and that was critical because we almost lost one of the key engineers in the company, and that person almost got hired away. And if that had happened, if they had access to our database, we have this high level proprietary database, which has all the chemical formulas that we've developed over time. If the engineer had access to that, it would make him walking out the door, make it easier for him to take that with him. And so it's important to have access limited to a handful of employees. It's important when you're transmitting anything that's a trade secret to encrypt the files. And it's really important to limit the ability of people to work on anything that's a trade secret at home. It's of course fine for the founders who have an ownership stake in the company to do that, but at this level, I'm talking about employees. And again, having NDAs with any company outside that you may share that information with will be critical. So let me talk in the 5 or 6 minutes I have remaining about some of the key provisions to have in the IP agreements you may have. So some of the agreements may be confidentiality provisions that you would have in your employment agreement. Very often you may have or find a need to joint venture with a company, and so you may have a joint venture agreement or joint development agreement, which is usually something less than a full joint venture where you just agree to bring in another party to help you develop the technology. Sometimes you don't have the resources or the funds to do that, and if you're not able to raise the funds yourself, it's helpful to have an agreement or a joint development partner. And it's really important in those agreements to do your best to protect the IP. It's important to make sure that you own any ancillary IP that gets developed. So obviously you're bringing intellectual property into the relationship as a consequence of working, for example, with a joint development partner. IP often is generated. And so the first line of attack is to make sure, if you can, to make sure you own that technology. Anything that is developed through the course of the relationship. You'll want to make sure that you own it. On occasion, you may have to provide a license back to your joint development partner, and that's fine so long as it's non-exclusive. But it's important that you can do everything you can to own the technology. Also, you need to be careful about one of the common clauses you might find in agreement is an affiliate clause. This is where affiliates may have rights to IP, and you have to be careful about that because very often those clauses are not close-ended. They include affiliates that may come into being in the future. And so, for example, you may give a license to a joint development partner, which may be a small company, but they in turn may end up getting bought out by a very big company. If you've given license rights to that smaller company and any of their affiliates, if they get acquired by this big company, now all of a sudden, as a consequence of a clause in an agreement that very few, many people just sort of gloss over, the affiliates clause, you've all of a sudden went from licensing a small startup to licensing potentially Google or Apple or somebody like that. And so it's very important, I think, some of the most important clauses I've seen, you know, and you should really focus on are ones that are often, you know, glossed over. And that's the affiliates definition, because you may end up with an affiliate of one of your partners that's huge and takes away huge economic interest in what you're doing. And then the second thing to watch out for in some of the agreements is the assignment clause. That's the clause that says if you sell the company, or your partner sells their company, or they sell, you know, the license agreement, that the party who buys it basically steps in their shoes. And that same thing can happen because the purchaser of the company or of their rights may end up being an enterprise which is much bigger, and that may cause you to lose, you know, significant value in your company and what you're attempting to do. And so it's really important to have those provisions in there. You know, in employment agreements, it's really important with employees to make sure that any intellectual property rights that they develop, they assign to the company. I can't tell you how many times I've dealt with companies, including, you know, Fortune 500 companies, that have failed to do that. I have a client right now, which is a huge gas company, that failed to get an assignment from an employee. And the employee, while they were working for the company, went off and filed a patent application on a competing technology. And now this is a technology at the time the client really didn't care about, and now it's a key technology the client is getting into. And we have this thorny issue of having to deal with this patent that this employee filed and kept for himself. And so, you know, we're trying to decide, do we sue this person? And we're doing everything we can to get those IP rights back. But it would have been a heck of a lot easier and cleaner for the client if in the employment agreement, you know, there was a clear obligation that they assign over the inventions to the employer. And so that's a key provision to have in employment. One of the things, you know, that happen often is, you know, again, you're excited about getting the money, bringing people into the company, you're excited about employing people, and you forget, you know, to get an employment agreement with these people. You know, very often in our case, the last 2 years, you know, during the pandemic, the oil and gas market was really tight. And so we had to lay off some folks. And, you know, having a robust employment agreement is critical in that case, because it enables you to not only protect the IP you have, but also anything that the employee may have developed. And so that's critical. You know, it's one sort of last thing, just sort of a tax issue that cropped up. And this actually came up in a license agreement that I had in one of my litigations. You know, ultimately, if you end up licensing your technology to another party, there's different ways of doing it. Sometimes it can be a license fee that is a lump sum payment made over time. The more common scenario is to have it structured as a royalty. The royalty is often the better structure than the lump sum payment over time. I was in the middle of settling a case when we had a scenario where it was a lump sum payment. In order to get the deal done, we determined that it was better to pay that lump sum period over a period of 5 years. And before we inked or about to ink the deal, the CFO of the company called and said, you realize that even though this payment's made over 5 years, from a tax purposes, it's considered as all made this year because it was characterized as a lump sum as opposed to a royalty. And so, you know, Ian had mentioned, you know, call upon, you know, your accountant friends and your CFO friends. It's important in structuring license agreements to have a full understanding of what the tax implications potentially are in how your agreements are structured. So I think we've reached kind of the main part of our time. I think now the idea is that we would try and answer some questions. And I don't know, were you going to field them for us, or are we going to try and read them out in
Yes,
the chat?
I
Okay,
can.
great.
I can.
Great.
I've been keeping, yeah. So our first question was from, sorry. Yeah, our first question was from Charles, and the question is, if there a concern that web-based legal document creation will be valid in every 50 states?
Charles, that's a really good question, and one I'll jump in on just because of my experience in working not just in the legal profession, but with legal technology. So short answer from my end is that this is definitely not a concern. I actually think that web-based legal document creation is the future, if not the present. And it's when we do this technology right, it's going to free up attorneys and really free up a lot of GDP in the economy to spend time working on more strategic, more thoughtful legal work. So I'm a big advocate of sort of what you describe as web-based legal document creation or automated document creation or legal technology. There's a lot of new AI products in the legal tech space, which, I think ultimately, if we get it right, will be a positive thing for everybody. Now, that being said, what we need more of is regulation. And we're at a sort of a political gridlock moment right now with our country, which hopefully will evolve out of at some point. But it's very difficult for us to actually regulate this technology in the proper way. So I think that state bars need to sort of step up and sort of learn about these technologies and give us the rules of the road, because there are ways in which web-based legal document creation and legal, just legal technology in general can go askew if it's not properly regulated. So I think it's an interesting question. It's not a huge concern for me, but I do think we need to regulate it properly in order to protect everyone that's going to essentially be signing these new sort of AI or web-based legal documents.
Yeah, thank you. And also we have another question from Richard. How advisory board contracts are structured in terms of comp and expectations?
So I think from the, I did mention the advisory board contracts as being a must-have, and I'll let Paul sort of provide some context here because he is actually on a board. What I've seen is what we typically do with clients is they're independent contracts, so they're not like employee agreements. So it is a separate document. And what we like to have is a very clear exhibit on that document that explains what it is the advisor is doing and what they're getting in consideration for that support. And what I've seen in terms of comp are typically stock options. I think in some cases there is potentially cash that can be paid, but I typically haven't seen that as much. It's usually structured as a stock option that vests over a 2 to 4 year period. And the typical amount that I've seen is 0.5% of the company to up to 3%. Any more than that, and you're taking a pretty large chunk out of the company, which you're going to need to build option pools for your employees, for other investors who are coming in, and also for yourself, because you want to have some incentive at the end of the day too, and have a good piece of the pie. So the advisors are typically, that's how we structure the agreements. And in terms of compensation, it's 0.5% to 3% equity stake that vests over a 2 to 4 year vesting period.
Yeah, and in my case, it's a little bit different. I just get shares for my time. And so we kind of look at what would my normal billing rate be for the advice that I'm given, and then the CEO, who happens to be a relative, converts that into shares. Sometimes lawyers are the worst clients, so I actually don't have an agreement with the company, but as one of the investors in the end of the day, I'm really trying to help the company grow and do well. But that's what I ended up doing. But I think you touched on a really important point, Ian, and I think it's critical because we've had to go through this, because the oil, the technology was just getting up and going, and then COVID hit, oil sort of bottomed out. We were going to have to close the doors. We needed to get more money. And so the dilution of the shares, because you're getting your board to help, you're getting your advisory board to help, there's going to be some rough patches sometimes in getting things going, especially if you decide not to go the private equity route to get money. I mean, we could have done that a long time ago, but the CEO doesn't want to do that. And so one of the things you have to be really, really careful and watch is, how much are you giving away to your employees, to your advisors, and then sort of, second and third round funders, in order to keep the company going. that's a real challenge. And there's no easy answer to that. And so anyway, I don't know if you have any thoughts on that.
Well, you gave me some really a great idea on how to structure advisory board contracts. That's a very creative approach, and I think you speak to an interesting aspect of the advisory board, which is, look, there's no template at the end of the day. That's kind of the fun thing about working with seed level companies is everything is a little bit different and bespoke, and there's a freedom to think, creatively about how do we give everyone a proper incentive. And yes, to your point, I've seen that too. Very early on, there's a lot of excitement. There's always excitement in the beginning. And I've seen founders who want to give away large chunks of the company, and they get involved in these contracts, and things get signed, without the proper anti-dilution clauses or what have you. And lo and behold, it becomes difficult to actually get more capital because you've already given away your company. And if you're, to somebody in a large portion, and if that person isn't actually bringing anything to the table, I have seen a lot of advisors who just sort of want to get on the website and update their LinkedIn and use it for, their own personal marketing. You really want to make sure that your advisors are doing things, that they're actually ones who are going to help you grow your business, that are going to make the introductions or give you the advice, meet with you, at least quarterly to make sure things are moving along. So that's why I put that advisory contract, as a must-have. Like to your point, there's many different ways to structure them.
Okay, we have another question from Cap Thomas. From the investor standpoint, what are the best places to start if you are new? And Cap has participated in 6 months to 3-year real estate equity deals and would like to expand to an angel investing eventually, forums, books, networks, and associations.
Yeah, I think I did see that chat, and I think best place to start, I actually am going to direct to another comment, which came from, I think, Tom Carew, where he's talking about an alternative approach that harmonizes incentives to work with angel groups who typically do not charge fees, do not require compensation, or are motivated to help the company succeed because they've invested their own money. I would try to find something like that. There are a lot of really great incubators and actually people within our own Trinity community that would be willing to be a part of an angel investor group. You want to find your champions, people who believe in not just your technology or your idea or your product, but believe in you, as someone who can effectively grow a company and run a company and make that a success. So I think a good first step, obviously talk to Paul and myself. We can help you with all the legal elements, but I think getting tapped into an incubator or an angel group in the type that Tom Carew described in the chat is a really good place to start, because you can get a lot of advice and frankly, you can get access to capital networks that others might not have access to, and give you a leg up on the process from those who are really experts in it.
Yeah, that's exactly right. And, I think there's traditionally two sort of, well, three sources. Obviously, friends and family is always a great start, right? But, in terms of outside money beyond, private equity and the bigger institutional investors, most universities and, like Trinity have these networks and incubators. And then a lot of industries have them, right? So here in Houston, we have sort of two levels of incubators, one for the oil and gas industry, and one, because we have the world's largest medical center here, we have, a number of biotech incubators. And I know there are some in Southern California and Boston as well. And so, depending upon where you're located, you'll want to connect. Obviously, you may want to connect to your local university because they often have those resources, as well as the industries, and sometimes trade associations will be involved in that as well.
So I think now we are running out of time, and to keep the conversation going on, what's the best way to contact with Ian and Paul, for anyone who want to have a further discussion? And we still do have questions in the chat, so for those people also to contact you.
Yeah, Doug, I really want to answer your crypto question and learn more about your knowledge in the fintech space. That's the one that's sort of all over CNBC right now, what's happening with crypto. And I know a lot of crypto founders right now, and we can chat more about that, Douglas. But if you want to get in touch with my firm, with me personally, you can find me on LinkedIn. I'm just at Ian Connett. Our law firm is called Connett PC. That's connettpc.com, CONNETTPC.com. I'm not as active on Twitter, but I do have a Twitter account if you want to try to connect there. But best bet is just to find me on LinkedIn or get in touch with the Stube or Melissa. I'm sure they can help connect the dots if anyone's interested in talking some more.
Well, I don't feel so bad, Ian, not being on Twitter. I thought that was more of an age thing with me because I'm a couple decades older than you. But I am on LinkedIn.
Whole separate legal conversation there with Twitter.
That is. I am active on LinkedIn. I'm with the law firm of Baker Botts here in Houston, Texas. And so you can find me at paul.morico@bakerbotts.com. So just search Baker Botts and search my, and Botts is BOTTS. Just search Baker Botts in my name and my profile will come up, and you can send me an email. I think my phone number is there as well, and I'd be happy to connect.
Could I ask a quick question?
Sure.
Yeah,
I
please.
have an existing company, and they hired me to accelerate their existing business, and I want to convert it into a non-correlated asset fund. Is that something that you guys could help me with? I'm trying to get investors.
That's probably more your bailiwick, Ian, than mine.
Yeah, I mean, potentially, it sounds interesting. Let's definitely connect and talk offline about it. Yeah, if I can't help you, we can point you in the right direction.
Yeah, thank you. The 5 bullet points. I have everything. Well, I have 3 of them. I don't have the capital, and we need to protect the IP. So thank you so much, and I'd love to get your thoughts on what we're doing. My white paper is done, and we've got a tight opportunity here. It's just a revenue share, so it's different. It's not a startup.
Awesome, Peter. Let's connect on LinkedIn. Definitely happy to learn more.
Awesome. Thank you, guys.
Yeah,
You did
thanks.
a great job. This was awesome.
Thank you.
Thank you so much, Ian and Paul, for your presentation time and for joining us today. We really appreciate you taking your busy schedule to join us today, everyone. Thank you so much, everyone, for joining us, and be active in the Q&A session. Please look for our post-event survey in an email tomorrow, which will include Paul and Ian's contact information. And please join the Trinity Entrepreneurial Network, complete your profile on the Bantam Career Network, and follow up with Melissa if you have any information, if you want to know any more information, or if you have any question. And thank you for today.
Excellent. Thanks, Itsu.